Welcome to Bites of Light. Today we are going to deal with theory of separation of powers and checks and balance. So let's understand what is theory of separation of powers. The theory of separation talks about the separation of powers between three organs of the government, that is the legislature which makes the law, the executive which implements the law, and the judiciary which scrutinizes and checks whether the law made and implemented are constitutional or fair. That is, if this tree is a government, then legislature, executive and judiciary are branches of the government. Let's get deeper into it. Montesquieu, a French philosopher, has said that these three organs should be separated from each other through a watertight arrangement, and that is, those who are the members of legislative should not be the members of executive, and they should also be not the members of judiciary. That is, each organ should have their separate influence, task, and functions, and no organ shall influence other organ. That is, judiciary, executive and legislature, they all should be separated, and that is through a watertight arrangement. That is, there is no way one does the task of another. That is, all these should be perfectly separated. Coming to another point, James Madison, former American president, said that concentration of all powers, that is legislature, executive and judiciary, in the same hands is the worst example of tyranny, and principal feature of democracy is the separation of powers, that is concentration of all the powers. If legislature, executive and judiciary, all these powers are vested in one particular person or one particular hand, then it is the worst example of tyranny. For example, Adolf Hitler, Muhammad Gaddafi, King Jong-un, all these people were dictators, and one thing common in their rule was the tyranny that the common people had to suffer. Coming to the next point, let's see how the separation of powers is practiced in United States. United States Constitution was the first one to apply the theory of separation of powers. Article 1 of US Constitution, it states that all the powers of legislature shall be vested in the Congress, that is two houses, that is House of Representatives, that is lower house, and House of Senates, that is upper house. This is the House of Senates, that is the upper house. This is the House of Representatives, that is the lower house. Article 2, all executive powers will be residing with the President. All the executive powers is residing now with Mr. Donald Trump. Coming to the third article, all judicial power is residing with the Federal Supreme Court. That is, with this particular Federal Supreme Court, all the judicial power is residing. That is, there is clear-cut separation of powers. Now coming to another concept, that is checks and balances. So let's see what is checks and balances. Apart from the separation of powers, there are also presence of checks and balances. And why? Checking is made because if not, a particular organ may exceed its jurisdiction. That is, there should be checking and as well as balancing so that there is no exceeding of jurisdiction of one particular organ by another. Let's see how the checks and balances are maintained in the US Constitution. First one is checking on Congress. The Supreme Court keeps a check on the Congress, that is not to violate the spirit of the Constitution. That is, Supreme Court is the one which keeps a check on the Congress. This is the upper house. Coming to the checking on President. If the President does anything that amounts to treason, then the legislature can remove the President. That is, the legislature is the one which gives a check on Mr. President. Coming to checking on judiciary, that is checking on Supreme Court. The President appoints the judges provided with a ratification from the Parliament. That is, both keep a check on judiciary. Legislature also possesses the power to remove judiciary. The Supreme Court is kept under check by the President as well as the legislature. And in the US, the ministers are not part of legislature. That is, Donald Trump is not a part of the legislature, but only executive. And president is the head of the executive and not a part of legislature. So this was about US and its separation of powers and checks and balances. Let's come to our scenario, that is Indian scenario. In Indian scenario, India follows British parliamentary model of system where cabinet is the supreme and not the president. In cabinet model of government, there cannot be clear-cut separation of powers. That is, we follow a British model of system where it is unclear. The separation of power is very much unclear. Coming to the next point, here, the executive is derived from the legislature. That is, PM Modi is a member of legislature and also the executive as well. And Article 50 talks about separation of powers, but not in the strict sense as compared to the US Constitution. That is, Article 50 is the one which deals with separation of powers, and the executive is also the member of legislature. That is, executive, which is PM and the Council of Ministers. Our PM and the Council of Ministers are also part of the Parliament as well. Next point, in 1772, Warren Hastings created the post of district collector, where he was acting as both district magistrate and judicial magistrate. That is, both the power of executive as well as judiciary in the same hands. District magistrate and judicial magistrate under one post of district collector. This is Warren Hastings. So let's see what are the duties of the district collector. The district collector performs the duties of collection of tax, that comes under executive, law and order maintenance, that also comes under executive, and punishment, which comes under judiciary. That means earlier there was no separation of powers between executive and judiciary. So what happened then? Then came CRPC. That is, to separate the executive and judiciary, the Code of Criminal Procedure came in 1950, where judicial magistrate was snatched from the powers of judiciary and the powers were given to a new post, that is district judge. Executive and judiciary was separated. Coming to the next point, but there is no separation of powers between legislature and executive, as executive is a part of legislature, and as India follows a parliamentary model of system, there cannot be clear-cut separation between executive and legislature. Coming to the next point, that is in Keshavananda Bharati versus State of Kerala, a landmark case in 1973. This is Keshavananda Bharati. The Supreme Court said that the separation of powers is part of basic structure and it cannot be amended. That is, whatever things which are part of basic structure of the Indian Constitution cannot be amended. Coming to the next point, let's see what are the changes in doctrine of checks and balances. Legislature is kept under check by the judiciary. That is, it has undergone a lot of change. That is like power of judicial review, where judiciary can review any action and law made by the parliament, the actions taken by the executive, and anything can be reviewed and struck down. This judicial review is also part of basic structure. You can see in this picture, judiciary, which is holding a hammer, is heavy on executive as well as legislature. Coming to the next point, other ways of keeping check on legislature, that is through judicial overreach, judicial activism, judicial adventurism, and public interest litigation. Coming to the check on executive. Executive is kept under check by both judiciary and legislature, and by the legislature through the help of question hour and no confidence motion, and by the judiciary through judicial review over executive action. Example, PM Modi is asked questions by question hour and can be removed by no confidence motion. That is, the executive and the Council of Ministers is asked questions and can be removed by no confidence motion. That is how the check is kept on executive by both legislature as well as judiciary. Coming to the case of judiciary, that is check on judiciary. Judiciary enjoys more freedom than other branches of democracy, and the checks and balances doesn't affect it much. That is, in the earlier scenario, earlier according to the constitution, the president shall appoint the judge of Supreme Court after consulting with such judges of the Supreme Court and High Court as the president may feel necessary according to the Article 124 of Indian Constitution. In that case, anyone could be appointed as judge of the Supreme Court. That is, President consult with judges of Supreme Court and High Court as the President may feel necessary to appoint the judge of Supreme Court. Coming to the next point. What changes came over a period of time? That is, over a period of time, there was role of executive in the appointment and removal of judges, and the members of Supreme Court could be removed by the members of Parliament. Thus, the appointment and the removal process had checks and balances. That is, the executive and the legislature had check on the appointment as well as the removal of the judges. But what about now? Let's see what is collegium system. Collegium system is one in which the whole appointment system of the judges were changed and the members of judiciary were appointed by judiciary themselves, and that particular system is called the collegium system. Collegium system consists of executive members of judiciary, and the system gives names, and these names are binding on the president, and the appointment process is not under check as the judiciary decides the judges, and the removal process is so tedious that since 1950 till now no judge has been removed. So that is about the collegium system and text regarding judiciary. So that was about this video, guys. That is, we have learned about theory of separation of powers and checks and balances. What do you mean by separation of powers? What Montesquieu said and about watertight arrangement. All the powers being in one hand and being the worst example of tyranny. About United States Article 1, Article 2 and Article 3. We also learned about checks and balances. About checking on Congress, checking on President and checking on the Supreme Court. Coming to the Indian scenario, we learned about British parliamentary model of system. About the separation of powers between legislature and executive. The separation of powers between judiciary and executive, the duties of the district collector earlier after the induction of CRPC, the absence of clear-cut separation of power between legislature and executive, about Keshavananda Bharati versus State of Kerala and basic structure, about the changes in doctrine of checks and balances in India, the way judiciary checks legislature and executive, about judicial review, judicial activism, judicial overreach, judicial adventurism and public interest litigation, about the check on executive, the question hour and no confidence motion, about the check on judiciary, the earlier scenario and what happened over a period of time, and the present system, that is the collegium system. This was all about our video, guys. Thank you so much. Subscribe for updates and press the bell icon for notification. Thank you.